So is your spouse or soon-to-be ex-spouse overspending and you want to lock them out of the accounts? This is exactly what Marla is facing. So she writes, "Dear attorneys, my husband has a severe spending problem, and it's one of the reasons that led me to file for divorce. We have a joint bank account, and I want to take all of the money out so that he can't access it.
Am I the asshole if I do that?
Sincerely, Marla Money." Well, Marla, this is a very common problem that we see all the time. So here's what you need to know. First, overspending can be rather dependent upon the person who is looking at it. In some cases, you may think that going to Starbucks every day is okay. In other cases, somebody may think that going to Starbucks every single day is completely overspending. So the answer is not as black and white as you may think. We would actually need some more information to get you the real answer for your specific question. However, let me talk about some other things that we can tell you before we answer your ultimate question. Let me just tell you what happens when you actually file for divorce. When you file for divorce, automatic orders go into effect. Automatic orders are literally exactly how they sound. They are orders that automatically go into effect by the court and are thus court orders that you both need to abide by. Amongst these automatic orders are certain things that you can't spend money, neither can he, and neither of you can accumulate debt, modify your bank accounts, take money out of the accounts, and so on and so forth. If you were to entirely drain the bank account, well, then you're depleting the entire asset, and thus you would be in violation of those automatic orders. Now, if you were to continue paying all of the essential bills like your rent or mortgage, the electric bill, and so on, then you might have a chance of not actually being in contempt of court. However, it is risky. Look, a better option would be for you to only remove half of that money. There are some caveats to that. You can actually pay for some bills prior to removing some of the money, such as your attorney's fees. So if you were to only remove half, then the court would probably consider that to be a fair and equitable solution to your problem. Honestly, the best advice is to consult with an attorney. There are certain things that you can move from one account to another, and there are certain bills that you can pay for without being penalized by the courts. The only way that you personally can figure that out in your specific situation is by talking to an attorney and figuring out exactly what it is that you have, what you need to pay for, and how that impacts your financial situation. Bottom line, Marla, I don't think you're an asshole. I think that you're trying to protect your money. However, if you're talking about just doing one blanket approach because you think that it's going to stick it to your ex, well, then you might be erring on the side of an asshole. A better approach would be to bring it to an attorney, talk to the attorney about your options, and to move forward in a very planful and legal approach. So, Marla, I hope that answers your question. If you or someone you know needs more information on this topic, then feel free to give our office a call, email us, or go to our website at www.wolfandshorelaw.com. I'm Kristen Wolf at Wolf and Shore Law Group, and we are a family law firm here in the state of Connecticut helping you to reach a resolution of your family law case peacefully and with ease.